Hello and welcome back to my channel. I hope you're having a great day. Well, there's lots of Twitter movement and everything since we had the hearing today, and there's media come out as well. We're getting this talked about, and we need to get this talked about. So there's two Twitter comments I want to bring your attention to. The first one is from Jordan Shanks. So this is what he says. This is on Twitter. On the 3rd of June 2021, Paul Sylvain, I cannot pronounce his name, and I'm really sorry, of Mark O'Brien Legal served me a statement of claim that, in my view, was defective, late, and laden with errors. The day after, on the whim of Paul's client, my employee, Christo, was violently arrested and his family assaulted for merely attempting to correct Paul's errors. After being in prison, Christo was released only to be placed under the most draconian bail conditions that prohibited him from even working on my defence. I didn't have a team of lawyers immediately ready to go to defend myself against any of these obscene abuses of legal system instigated by John Barilaro. After all this, Barilaro's barrister, Sue Chrysanthu, who's also Christian Porter's ex-barrister, is complaining that I filed my defence 3 days late. In my view, this is a disgusting and disingenuous stalling tactic that only serves to highlight the desperation of John Barilaro and his legal team, who appear too afraid to fight my defence on its merits. So, here is my opinion on this. Sue Chrysanthu, or anyone that any applicant, when they deal with the respondent's affidavit or claim or defence, is going to try and poke holes of it. That is their job. I don't know whether it was filed late. I don't know any of that. But it doesn't surprise me that she's gone to that tactic. Now, I'm assuming that this has been approved by his lawyer. I do think, though, it was an overreaction. I do think it was an overreaction. I was surprised that they hadn't sought leave to serve yet, because the case does rest on good part of that case. The other person that tweeted today was Helen Dalton. She said, "My name is John Barilaro. Me Port Barilaro. I have no apology because at the end of the day, I will stand up and fight for our community." Barilaro was saying in May last year. That's all tweeted along with the legal defence. So that's very interesting. This is the Guardian, and I found that the Guardian has given us the most balanced view. Other places that I've seen have been really not nice. This one says John Barilaro lawyer to launch friendly defence in defamation matter. Barrister Chrysanthu, the Deputy Premier, told court there is barely a paragraph of Jordan Shake's defence that will survive. But that's their job. It's their job to pick up the defence, finds holes in it. It's Dr. Cullen's job to actually show the court that what they filed is correct. Remember, that's their job. John Barilaro will launch a wholesale attack on the defence filed by YouTube comedian Jordan Shanks in his defamation battle against New South Wales Deputy Premier, saying there is barely a paragraph of the document that will survive for their challenge. Friday was the first case management hearing for Barilaro's defamation case against Shanks, a former male model and YouTuber who uses non-diplomatic FriendlyJorides Legal, the Deputy Premier claims are vile and racist, and brought him into public disrepute, odium, ridicule and contempt. Barilaro alleges the video, published in September and October last year, carried the imputation that he was a corrupt conman, committed perjury 9 times, corruptly gave $3.3 million to a beef company, and corruptly voted against a royal commission into water theft. On Friday, Barilaro's barrister, Sue Chrysanthu SC, told the court that the defence filed by Shanks' lawyers was defective because it failed to explain why the perjury claim is justified. We're making a wholesale attack on the defence, Chrysanthu told the court. There's barely a paragraph that will survive given the lack of particulars. Shanks' lawyers have argued justified truth over the perjury claim, but the defence documents state issues of parliamentary privilege restricted them from making those arguments. On Friday, barrister Matthew Collins QC for Shanks saw a further hearing to flesh out the questions over privilege. But Chrysanthou took issue with that, pointing out Shanks had filed his defence late while also failing to provide particulars on the justified truth claim. The document, she said, made serious allegations in relation to my client with a complete failure to provide particulars. He's accusing a minister of the Crown of 9 counts of perjury, not one particular. She said the leisurely timetable proposed by Collins would waste the court's time. The videos are still online, and not only that, but Mr. Collins' client continues to post defensive videos not only about my client, but about my instructing solicitor. I'll just stop there. I have not seen any videos about that, to be honest. Is she talking about the service ones? I don't know. Again, she's not been forthcoming with particulars. Chrysanthou argued that both Barilaro could not waive parliamentary privilege, and it was necessary to Shanks to provide particulars of how he would prove the truth of perjury imputation. She said the request for Barilaro to waive privilege was bizarre. Why should we take Mr. Shanks's word that he has a defence that he can properly particularise, she said. Justice Stephen Rares set down the hearing in the matter for the 23rd of July, while Collins committed to providing an outline of particulars before that date. Collins also flagged that Shanks would seek a jury trial in the case, a rare course of action. A rare course of action in the federal court, where contempt trials are usually heard by judges alone. Google is also being sued by Barilaro as the publishers of YouTube, where the videos are hosted, and his lawyers are seeking judicial permission to serve the tech company overseas. So Google hasn't been served yet, from what I can work out, so they need to be served. The matter of a jury trial has to also involve Google. And, yeah. As I said, that to me is a fairly good summary of what actually happened. It wasn't what the standard said, and, she did say that the defence was defective, but that's what they all say. That's what they all say. That's what she's paid to say. She's not going to stand up there and go, "Oh, Your Honour, they've put in such a good defence. Your Honour, we just want to congratulate them on the good defence." She's always going to go, "No, it's defective. I'm going to find," and her job is to find holes in it. Her job is to make it hard for the defence. That's her job. The defence's job, Dr. Collins's job, is to firm up every statement that they've got and to go, "Here it is. Here's when it was said, date, time. Here's the law, blah, 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 blah," and make it hard for them to find holes. That's what it is. It's like, So the fact that Chrysanthou said it was defective, it's the same. I heard, when she was a witness in the Joanne Dyer, in her own Dyer versus Chrysanthou, when her conflict of interest came up, there was, there were questions put to her as well that she had to answer. So it's all just part of the process. It's all part of the process. So it will all come out in the wash and we'll find out. But this parliamentary privilege is going to be a very interesting one. Because again, if parliamentary privilege is waived, it also means that politicians are going to have to be careful what they say under parliamentary privilege, because then it could be fair game. Very interesting, isn't it? This case is going to be a landmark, I think, in my opinion. A landmark case for years to come. It's really pulling out some really interesting, bizarre issues. But I don't know that they'll get a jury trial, though. Anyway, we sit back and we wait till the 23rd of July and see what happens. Okay, so thank you for joining me. Please hit the like button and subscribe and leave a comment and say hello, and I'll catch you later.